Welcome to the November 26, 2018 Zoning Board of Appeals meeting of the Town of Raymond. Zoning Board of Appeals will come to order. The board does have a quorum this evening, and I'm now going to do a roll call. Starting on my left, Patricia Beaton, Joanne Stinson,
Len Sorelli,
Rick Welch.
This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that's being said and to look at all the exhibits that are presented. Please notify the chair if you are unable to see or hear. The board works from a published agenda and will be considering tonight's items in the following order. Election of officers, new business, we have 2 appeals that we'll go through later. Consideration of an applicant for a vacant seat on the Zoning Board of Appeals, Code Enforcement Officer communications, and then adjournment, hopefully. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare a written notice of decision. Because of the notice of decision may substantially affect any appeals rights and also a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its discussion. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of this board's decision. Also, to be certain that you preserve your individual right to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to stand at the microphone, to sign to the speaker sheet, state their name, address, and affiliation with the application, whether you're for, opposed, or neutral. All persons speaking shall address all remarks or questions through the chair. The meeting is not over until the board has formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or conducted outside of the meeting room. Okay. So to begin this evening, first have election of officers. As many of you may know or not, Larry Murch, who served on the Zoning Board of Appeals for 30 plus years, has decided that he's had enough. So, and we haven't reviewed, we haven't redone elections for the board in a long time. So do we have any nominations for chair?
I would like to nominate you.
Do we have a second?
Second.
All those in favor? I don't want to vote for myself, so we'll take it. Do I have to vote for myself? Okay. Any nominations for vice chair? Len Sorelli? Second?
I nominate.
I second. All those in favor? Okay. And Mary, do you know, I know this is done on an annual basis.
Mm-hmm.
So will this go, is it a calendar year? Will this be just short term and we revisit it after the first of the year, or we go a full year?
You know, I honestly don't know.
Okay.
I'll have to take a look at that, since
No.
we've not had elections for this board. And
In a long time.
I can, unless things have changed in the last 4 years, the appointments are usually done in the first selectmen's meeting after town meeting.
After
So
town meeting.
that
This
might
is-
be an appropriate time to do it.
I know
Okay.
the planning board does it, usually does it in June.
First meeting after. Thank you so much, Louise. After town meeting. Okay.
I have 2 things. Since we have 2 applications here tonight, there are 2 sign-in sheets, and each one has a title
Okay.
on it that tells you which one it is. And I'm going to see if we can lower the heat in here. Does anybody have an objection?
No. So if that's clear, you guys, there's 2 different sheets for the 2 different appeals that we're going to hear tonight.
Hayden Road and the conditional use down on Roosevelt Trail.
So the first appeal up this evening is Gerald Caherl, if I pronounce that correctly. Address 12 Hayden Brook Road, map 008, lot 080, 000 in the RR Rural Residential Zone, and requesting a front setback reduction from 30 feet to 17 feet for an existing house, which I believe was built in 1996. And so anyone here to speak for the appellant?
Madam Chair, I'm Willie Audette. I'm here on behalf of Jerry Cahill. The request tonight is a result of Mrs. Mickelon passed away in June. Jerry's the son of Edith Mickelon. The house was put on the market. About a month after that, it was placed under contract with a buyer. A mortgage survey was done by a survey company, and it was found that the building was encroaching into the front setback. Buyer of that contract walked away because of just complications. So it was on my recommendation, I told my client to move forward to make a request to the town for the reduction of the setback. And as a result, it now is under contract, but the contract is subject to the sale is subject to gaining relief from the town for the front setback. I think we uncovered at the site walk that maybe understanding how it all happened, because everybody's asking how could this happen. One of the neighbors was at the site visit, and he explained the gentleman that Mrs. Mickelon purchased the property from, Roy Rayner, apparently placed structures on the site, and that apparently it was a shed that turned into a garage. And we believe that that's where the front of the building was established, but that's, it's kind of hearsay. We're not really sure of that, but it's where it's at. It's in violation, and we're here tonight asking for relief. Be happy to answer any questions that the board may have.
At the sidewalk, Scott mentioned that where the slab is where I guess a trailer used to be,
Well, no, that trailer used to sit out back.
but on that slab, he cannot build on that?
Well, that's up to you. I mean, that's one thing to clear that up. I saw it as a driveway because it was pitched, and it was finished off on all sides.
Right.
It just may be something, if you would like to add in there as a condition, that nobody's able to, that is not considered a structure and only a driveway, because that encroaches even more than what the structure currently does now.
I think we should include it.
And we would have no objections to that. We understand that, so.
For any of you that weren't at the site walk, what they're talking, it's like a cement slab, and the cars are parked on it now, and it's between the front of the house and the road. That's where that exists.
Right.
Great. Thank you.
Okay, thank you.
Is there anyone else to speak on behalf of this application?
Yes, my name is Carl Taylor, and I am the neighbor to the site, to the side of the site. I think at the time they had measured from the center of the road versus the property line. I don't know if it's the property line that's invading on this setback or just to the right-of-way, or is it my property line?
It's the setback line. It's not on a property line itself. It's still off the property line. It's just in what is considered a front setback, which is basically the building envelope that's on your lot, and it encroaches on that. It doesn't cross any property lines or anything like that. If I'm understanding.
Right. I was just curious if they were doing the 17 to 30 from the property line to the structure,
It's
or
from the property line to the structure.
from the property line to the structure.
From the road, what's
Right.
considered the front.
Yeah,
Right.
yeah, but it's the property line.
Right.
All setbacks are measured from
Which is what, 20 feet now, or?
the, 30, I
It's supposed
think,
to
in
be.
room, but I'm not, 30 is most of them.
Okay. Yep. And how far from a septic to a well, or from the house to the well?
He was okay with that as far as being close to that. Everything there was compliant.
But I'm talking about the well on the, towards the brook side, or the septic to the brook.
Well, the septic.
Because that's even further over, that's right on the property line. So I didn't know if there was, if there was a discrepancy on the measurements then, I didn't know the discrepancies on where the septic was placed to the brook or to the well.
Well, the septic is on the, am I looking at here, but not on the brook side of the house, it's on the other side of the house. So there isn't any really, there is some setbacks, but you can go within, if it was a replacement system, I think you can go within 5 feet of a property line with the septic system. So it's not considered a structure like a house would be.
Into a dug well?
The dug well, it all depends on when everything was put in. Again, I don't have the folder right here in front of me exactly, but if it was a replacement system, they don't have to be 100 feet. They can get a reduction.
I know there was 4 property stakes over there that were removed prior to these measurements, and it would probably help if we could get those back in place. They were removed by Burt Micklin, because when I purchased my property, there was the discrepancy on where those property markers were. So I had to pay for a full survey back then. They were put in, but then shortly after removed, so.
Well, I mean, that's up to the board as to whether or not they want to put that on the onus on the owner to have that pin. Is it just the one pin?
There was actually 4 of them over there that marked his property to mine.
Just to clarify, are you in opposition to this?
Well, I just wanted some clarification where the property line, the stakes were, because I think that's probably was what caused some of this to begin with. If they were taking measurements off stakes that weren't there, or he already had discrepancy where they were, but they were placed, the survey I had done, but then removed.
Yeah. Again, I mean.
I just don't want to see this happen with the new resident, I
Oh,
want
no,
him
I
to be
understand
upfront, what he owns and what he didn't, so.
I mean, in order for that, they would have to do an actual survey. This is just a mortgage survey. It's not a boundary survey. So for them to have to do that, I mean, that's up to the board. If they want to make it part of the conditions, they may or may not. I mean, you are putting.
Because, I mean, that structure now is within 20 foot to the property line. Yeah, I wouldn't want to see any more building any closer to it.
Well, if they were ever to come to me and want to do any kind of an addition, I wouldn't, for me, if it's that close, I would ask for a one-line boundary survey anyway, if they're that close to the setback, if they're within 3 or 4 feet of that setback line. I would want some clarification as to exactly where that line is.
Right.
And
Because I think there's even some
This appeal wouldn't
confusion.
have anything to do with any future construction or whatnot. Again, we'll address the cement slab that's there.
Right.
And our concern is the front setback on this. But this doesn't give anyone authority
Well,
or approval
even
to-
the realtor now, there's some confusion where it's at, because there was a neighbor that came over during the sidewalk and was asked permission to take down trees, and the way I see it, the trees were still on the other side of the marker,
Well-
And he told them sooner than later, and I go, here we go, we don't really know where those markers are.
Well, we're kind of getting into where it's more of a civil matter. Should they,
Yeah.
and the new homeowner could request a boundary survey.
Yeah.
They could do something like that. But it's not, like I said, what they're concerned about today is just the front markers, but something like that could be something that could be talked with the future home buyer or the seller if they were willing to do a boundary survey, but that would be purely up to them.
Okay.
I think if we were considering any, variance with any new construction on either of the sides of someone else's property line, we usually try to look at, making sure proper survey work has been
Yeah,
done for.
it just makes me wonder
Yeah.
if they did check to the brook. It's quite close there, even with the septic, that septic's probably another 14 foot further to the property line and to the brook, or to the dug well over there,
Okay, thank you.
Thank you.
Any other questions?
No.
Is there anyone to speak opposed to this application? You're in opposition? I am. Okay. Okay. Could you stand up to the microphone again then? Just to clarify, you're in opposition to the front setback reduction because,
I would like to see the property lines reestablished over there, just so I didn't have any future problems with the, you know, what's existing still today.
okay,
You know, I've dealt with it for 30 years. I'd like to put them in, at least be, the new owner be up front where they are. They are quite close to the house.
okay. Okay, any questions?
No.
Thank you. Okay, if there are no other questions and no one to speak on this appeal, then I'd like to close the public hearing portion of this appeal and have board discussion or open to motions. My first question, Scott, is, do you know back when the house was built, was all the proper permitting
Yes,
given?
yeah.
Okay.
Yeah.
Okay.
There's a permit for everything in there except for that, like I said, that concrete, but like I said, it's a driveway as far as I'm concerned because of the way it's pitched. It's not level like if you were to build a structure on it. But all permits we're taking out accordingly.
Okay. Any other questions? Anything?
I'm just clarifying, this is the front setback, it
Yes.
has nothing to do with the side border.
Okay, correct.
All right, I'm
Correct.
just making sure.
That's what was found in the mortgage survey, correct?
Mhm.
Was that the front was, setback was off. And just so we look at the proper ordinances and know what we are to consider here. This again is a rural residential zone. The minimum required setback from the front is 30 feet. Under Article 6B, the powers and duties of the Zoning Board of Appeals, we do have the authority to grant reductions from minimum setbacks. And of those, I'd like to go through one at a time. The Board of Appeals may grant reductions from the minimum setback requirements set forth in Article 4 of this ordinance according to all of the following criteria. Setback reduction appeals are only available to reduce the minimum requirements for setbacks of structures from lot boundary lines. Setback reduction appeals shall not be used and are not available from bodies of water as provided in this ordinance. Does anyone have a question about the first one? There's 8 of these. No concern?
No.
Rick? No. Setback reduction appeals may only be granted and are only available for lots with a residential dwelling as the principal structure, which
Which it is.
that's the case. The Board of Appeals may grant setback reduction appeal if the board finds that granting the setback reduction will not result in unreasonable interference with the privacy interests of the abutting landowners. There's nothing that I'm aware of there that we saw. In granting setback reduction, the Board of Appeals may attach reasonable conditions which it may deem necessary to serve the purposes of this ordinance. So that's something we can consider at the end, if we want to put conditions on this, if we vote for it.
Slab.
We
Yeah,
want to
you-
put conditions on the driveway or
Right.
slab, whatever
Okay.
you want to call it.
And we'll put that into the motion at the end then,
Yes.
so, yeah, okay. A setback reduction appeal shall not be granted to enable construction or renovation that will create additional dwelling units. That's not this case. Setback reduction appeal shall not be granted to enable construction or renovation that will result in more than one garage on the lot that is subject to the appeal. Any concerns there?
No.
No setback reduction appeal may be granted that will result in impervious surface lot coverage greater than 15%. There's no impervious surface coverage impact on this.
It's actually quite it's a big lot as it goes back, so
Yeah.
they aren't close to that yet.
Setback reduction appeals may only be granted to the minimum extent necessary to accomplish the purpose of the appeal. Setbacks may not be reduced by setback reduction appeal to less than the following absolute minimum setbacks. And for a rural residential zone, the front yard setback, the max we could go to, or min, however you look at it, is 15 feet. And this would take it to 17, is that correct?
Correct.
So we're within, we haven't gone beyond there. Okay, so with that, that's what we have to consider for the ordinances for the town of Raymond. With that, any further discussion on this appeal or motion?
I make a motion that we accept and allow for the variance with the condition with the number 4. 4?
Yes.
For that the slab is only used as a driveway.
Is that acceptable, Scott, that way?
Yeah,
Will not be built
or
upon?
no structures can be built on the
Okay.
slab
No structures built on the slab and
or driveway, however you, I'm not,
that,
it's
yeah.
better use the right terminology.
Do we have to say it's used as a driveway or just no structure to be built on
On
the
that.
slab?
On the, yeah, on that, well, I would, no structures to be built on the concrete driveway.
Okay.
Okay.
Is there a second?
I second.
So we have a motion to grant the setback reduction under the condition that no structures will be built on the concrete driveway. All those in favor? All those opposed? That's 4-0. That passes. And just, thank you for coming in and telling us what your concerns are. And just so you know, we're not ignoring your concerns. We hear you. And if any construction can't go on without the approval and going through Scott and the proper permitting and whatever. So if anyone were to try to build and it went beyond the side setbacks or the back for any reason, they would have to.
This would be a side setback. This is on the side of their
This is a front setback.
This is a front setback.
Yeah, so thank you, but keep that in mind if, you know, if any further construction tries to be requested on that property. Thank you, yeah, thank you. Okay, all right.
One final question, if I may. Scott, would you be issuing the letter of decision to us?
Yeah,
I'll be taking care of it.
yeah, Mary will be in contact with you on that,
Okay,
and you
'cause
gotta
we'll
register at the registry of deeds.
We'll take care of that.
Yeah,
Because
okay,
it's gonna be, it's a condition of the sale, and title company will,
okay,
we'll make sure of that. And
Alright.
then we'll forward a copy, the recorded copy to you,
okay,
okay?
yep.
Thank you, everybody.
Thank you very much.
Have a good night.
You too. Be careful out there. Okay, the second appeal is Mark Day, 1261 Roosevelt Trail, map 055, lot 021-000, commercial zone, and this is a request for a commercial conditional use.
Mark, before you start, I have to tell the board that I don't really know Mark, but him and his family have rented a summer place for me for the last 3 years. So he is known to me. So I don't know if you want me to excuse myself or not. I guess,
I have no concern. Do any members of the board have concerns?
I don't.
Lynn?
thank you.
Okay. Do you have any concerns, Mark?
No.
Okay. Great. Okay. You want to tell us what you're here for?
I want to open a used car dealership and I need a conditional use permit. I don't know what else you need. I've never done this before.
Memorandum came in.
Yeah, we just got a memorandum. Was that from?
Fire.
It was from our fire inspector.
Okay.
No, that's not fire inspector.
Oh, he's
No.
just speaking.
Just speaking.
Sir, are you speaking on behalf of?
Yes, I'm Ray Grant.
This is, we're talking about the fire inspector.
Excuse me?
This is the fire inspector over here.
Oh, okay.
Yeah, this, we were addressing a
Okay.
memorandum.
If you could wait
Okay.
1 second.
Sure.
We
Well,
just wanted
sign
to
it, that's
hear from the fire inspector.
Yeah.
If you could read your memorandum or go over it with us, that would be wonderful. And then we'd love to have you speak.
Sure, just from doing some research on the property, I'm new to the fire inspector role here in Raymond, so I wasn't familiar with the property, so I went to our file to see what was in the file regarding the property. And as noted in the memorandum, it's been a long-standing issue that the property hasn't been in compliance with the fire protection ordinance in a couple of areas, specifically the fire alarm system and having a Knox box installed on the property. So our concern is just to make sure that as a condition of your approval, that the fire protection issues at the property are addressed prior to certificate of occupancy or prior to opening the business.
And you said it was the fire alarm system and what was
Fire alarm system and the Knox box system.
Knox box system? Can you explain what that is? I'm sorry. I don't-
Yeah, it's a key box. It's
Okay.
a secure box that's put on the front of the building. The fire department's the only one that has a key that can access that box, and property keys are kept inside so that
Okay.
after hours, we can quickly gain access if we have a fire alarm or a call at that property.
Okay, great.
So, in addition to those two items, need to make sure that the property is properly addressed per the E911 standards too, and that's posted properly.
What was that last one?
Proper addressing on the building itself?
Yeah, on the building and on the sign, whatever
The
the
sign.
street sign is for the businesses at that location. And so we can find the property quickly and find where it looks like there's going to be multiple businesses, or there currently is different businesses there. So to break it down into suites or units, have that designated properly so that we can go right to where the problem area is.
Okay. Thank you very much.
You're welcome. Thank you.
Ray Grant, I'm the owner of the property, and I received somebody's email from the fire department Friday, and I was kind of shocked because I've been inspected every year, and the last time I was inspected was this summer, and the only problem they said I had was that the sign out front wasn't visible. And I ordered a new sign, I just hadn't put it up, the street address. So this isn't a minor alarm system you're talking. I have to have are you talking a fire alarm for every building or just that one?
For every building, you would need to have it to be in compliance with the ordinance. For this business to open, it's at least got to be in the buildings that this business is going to occupy.
Yeah, and sir, if you just keep this concern with this business for us, and then offline, if you guys want to talk about the other businesses, that's
Well,
great.
I
Yep.
needed to know what,
Yeah,
I'm fine with being able to do that one business and do the others at a later time, maybe one a year, because you're talking, this was a quick notice, but I've got rough figures from anywhere from 4,000 to 10,000 per building.
yeah, and I'm not sure, Scott, where does this fall with, we're just concerned with whether
Well,
you can get a conditional use for this one building, but,
it is as a rule of thumb that we can still issue an occupancy, but they have to get an agreement with the fire department on a timeline on when they can do stuff, or when they can have stuff done. Like I said, I not to, so it's not really necessarily what you guys should be looking at, but as far as is this allowed, the condition of use is this allowed in this building?
right.
And it is by giving you giving it your blessings on it. As far as the fire department stuff on that, I mean, you are, if it's an expense, you kind of got to be a little careful that you're denying the other gentleman a place of work. But, and again, the fire department I have worked with other businesses is to try to get everybody on board, and we do go through the landowner, not necessarily the tenant, to get that done.
Right.
And like I said, this is something that had just come up, and if it is, you know, I don't know if I'd wanna, it's up to you to put that condition on there or not.
But just to be clear, we're here to, as to whether per the ordinances, we can grant the conditional use, but anything from here on out will be done via you and the planning board?
Well, it'd be, well, no, it would be just, it'd be the fire department, us,
Yeah.
the code and
And the fire department?
and the landowner. Yeah,
The
fire
landowner.
department and landowner and us.
Okay, okay. But we can put conditions on, but as to whether,
Well, you know, I don't know if you really can in this case with the fire department or not. You can ask that it be in compliance, but don't give a timeline as to when it can be. That's something that should be worked out between the fire department and landowner.
right, okay.
And you get some kind of letter of correction from him, what he's gonna do. You could do that, you know, get a letter of correction so he can kind of come up with a somewhat of a timeline as to when he can do this stuff, so he doesn't have to do it before the gentleman can go in and work. And I think that's kind of what everybody's kind of looking for. It's you can get that. I just don't know if you can make it a condition or not. I'm not sure, but that
Yeah.
it is something that we would definitely want from the landowner as a letter of correction as to when are you going to get this done, and the fire department would make sure that it is done at the time that he states in the letter.
So we could possibly put as a condition that the three of you work together to,
Yeah, it's more of the fire department, but I'm
Okay.
on board with the fire department. That
Yeah.
my objective is to make it a safer building.
yep,
That's part of it. So yeah, you could, I suppose you could say something like that to, do we get a letter of consent agreement, or not consent agreement, but a letter of compliance as to what he intends to get stuff done in there. But like I said, you're kind of only really looking at the use and not so much.
okay. Well, we can have further discussion amongst ourselves. All right. Anything else you want to add?
I don't know. Does everything, we've given you the parking spaces and stuff like that. Is there anything you would like us to change?
No, you have plenty of parking out there ordinance-wise.
Yeah,
Yep.
yeah. That's the only question, that, you know, if it's
I
something
think we
that's,
understood that, you know, possibly a couple cars might be parked on the side.
Yeah.
So that someone can
Yeah.
see there are cars for sale.
yeah, and that he also will have to get those parking spaces licensed from the state too, when he does all this.
Okay.
Okay.
But I guess the basis thing is, you know, can he go about selling cars or not?
Yeah, and that's kind of, like I said, it's up to them as to they allow that conditional use, but once they
Right.
do, and then,
Yeah.
like I said, then we need to come into agreement with the fire department as
Yeah.
to what you plan on doing, and,
Yeah.
you know, I assume we're gonna be, you know, reasonable, but we would like it all compliance.
Yeah,
Okay.
okay.
Thank you. Does anybody have any questions of,
I just had a question as to where is the actual storefront gonna be?
It's the,
Out back?
yeah, the second building on the left,
Okay.
and it'll be that first end of the building, or that.
Yeah.
There's currently 3 bays, but the gentleman's only taking 2 bays.
and Mark, I had a question for you real quickly. You said this would not be auto repair, is that correct?
Correct.
Okay, so
I
this,
repair my own vehicles, so I can resell them, but not for repair.
but the
public.
business itself is
Right.
just used car sales? That's
Yes.
correct,
And
okay.
And he did say at the site visit that if he does any kind of bigger body work, that he would send it out rather than have it done there.
Excellent, okay, okay.
Thank you.
thanks. Okay, is there anyone else to speak on behalf of this appeal? Okay, if not, then the public hearing portion of this appeal will close, and I open up to the board for any discussions. And I can, I'll just read quickly that this is in the commercial zone. The Board of Appeals has the authority to hear and grant or deny applications for conditional use permits as specified within this ordinance. In granting permits under this section, the Board of Appeals may impose such conditions as it deems necessary in furtherance of the intent and purpose of this ordinance. Conditional use permits run with the land and thus pass from one owner of a property to the next. And under Article 4F, the commercial district, number 3 says, permitted conditional uses are outdoor sales and services. So if we can, you know, I guess the question is, do we consider this an outdoor sales and service? So that's what ordinance we have to hold ourselves to.
Okay.
So, are there any comments, questions?
I think we definitely need to include as a condition the letter of compliance.
With the fire code.
With the fire? And how would that work exactly? How do you see this? Can you speak to how you would see, and I know I closed public comment, but I just want to make sure we would get this right and not step out of our authority on this.
Sure. I see that if we come to an agreement on a plan of correction for bringing the property in compliance with the fire protection ordinance, I see that as how we're going to deal with this particular application.
And that would be you and the owner, correct?
Yes.
Would come up with a plan of correction.
Yes.
And so, like Scott said, we wouldn't put a time frame on
Well,
it.
that would just be something that they would work out the time frame on.
Yeah.
Right.
Yeah.
Certainly taking into consideration that it's been some of the issues are a long-standing problem, and it's going to take a little time to address the businesses outside of the one that we're discussing tonight. You know, we'll sit down and we'll come up with a plan of correction to deal with that.
And so, do you have to grant the occupancy permit for this?
Well, yeah, we would go in there and, well, it'd just be a change of use permit. It doesn't
Okay.
necessarily be it'd be an occupancy permit, yes.
Okay.
Yep.
So
And-
with that, would you need to see that this is done, or, sorry if I'm being too,
Not,
Just
well,
wanna make
no,
sure
I
we-
mean, I can issue the occupancy permit, but it could be a note added at the occupancy that several issues are outstanding. And a correction has been done, and just make a note of it on the occupancy permit.
And a copy of the plan of correction that we come up with would go into the file anyways for Scott.
Yep.
okay, okay. Okay, any other questions? Thank you very much. Would anyone like to take a crack at making a motion for this?
All right, I make a motion that we grant the change of use with the condition that a letter of correction is established for the fire code.
It should say conditional use.
Conditional use?
Say that again?
Conditional use instead of
Yes.
change of use.
Change in
Yes, sorry,
conditional
yes.
use.
Conditional use, letter of
Must be
correction.
corrected.
Letter of correction between the fire department and the owner of the building is established. And I'd like to amend that just to make sure it's in Scott's file.
Yeah,
as well.
they're quite good at
Okay.
that they will let me know if they've got anything. If they've worked out anything.
Do we have a second?
Second.
That's seconded. Okay, all those in favor? No one opposed, okay. The conditional use permit is granted with the conditioner that the letter of correction, and this is regarding the fire department memo of safety, is established, and per protocol now, that will be in Scott's file. Right. Okay. Thank you very much, folks. Appreciate it. Okay. And next on the agenda, Louise Lester, who's been so gracious to sit here and wait her turn, has an application for, we have a vacant seat on the zoning board of appeals. Louise, tell us about yourself.
I'm sorry?
Tell us about yourself.
Do I need to sign in first? I guess that's it.
Does she need to sign in?
No. Louise Lester, 10 Hartley Lane. A little while ago, I was witness to the Appeals Board meetings, and I was told that there was a need for volunteers. And I thought that probably I could be of use. I retired as town clerk here in Raymond 4 years ago, a little more than 4 years ago. And I think it's time for me to get back involved with the town again.
That's great.
Well, I guess that's to be ascertained. But I do have a certain amount of historic memory, having worked for the town since 1989, and in fact, in those days, and for many years thereafter, part of my job was taking minutes for the planning board and the appeals board. Obviously, a lot has changed in Raymond since those days. We have grown, and our ordinances have grown, and I think that the work of the boards in Raymond has become that much more important. And I think due diligence is very necessary for all of these things. So I do have a desire to serve, and if I can be of use, I think that's great. And I'd be happy to answer any questions that you guys might have.
Well, first of all, I commend you for staying involved. It's so greatly appreciated, and the town's lucky to have you stay involved and active with anything that's going on. It can only serve, I think, a positive end result. Any questions from the board?
Louise, you've been working for the town for a number of years, and I think it could be said you probably know most everybody in the town. Can you be objective if you're on the board with knowing all of these people, neighbors?
I
board
certainly
members?
can be. I had to be objective the whole time I was in the town office. You have to have an open mind, and you can't take personalities in the work that you do. So I'm very sure I can do that.
Give me one
I
second.
had a question, Louise. Just love to hear you just elaborate a little bit more on, you said, what do you feel is the responsibility of the boards and or committees you choose? You said, I also think that this board has the unique power to override town ordinances. Can you speak to that?
Yeah, I've always felt this way from the time I started taking minutes. Each of the committees in town have their job to do, but all of them are within the ordinance. The appeals board is the only one that can override our ordinance, such as you did tonight. You try and stay in compliance as close as you can get, but the fact is, you're giving allowances above and beyond what the ordinance allows. And I think that's an extremely powerful position. And I think it takes a very solid board and a very educated board to be able to accomplish that.
That's an interesting perspective, and I'm so glad you spoke to that, because I look at it differently, because we do have a unique opportunity to what I wouldn't call override the ordinances, because tonight we followed the ordinances, but we have some discretion, I guess, within them. Not that it matters, my opinion, yours, and it would be how we would all interpret the ordinances, so it's just a fascinating way to look at it, and I appreciate your thoughts
Well,
on
I think
that.
it's from my years of taking minutes. And as Mary knows well, because she's doing it, is that you have to concentrate so hard while you're taking minutes to get the pertinent information down that it sinks in. And maybe not per issue, but an overall impression that this is something that is different from anything else in town,
Yeah,
or I should say in town government.
it is different. Any other questions?
Louise, you said on your application that these decisions by the board should not be taken lightly. Were you referring to all boards or the appeals board? Or what makes you think that these decisions are taken lightly?
I don't think they are. I just don't think they should be. I mean, it goes from person to person. And I don't care whether it's budget finance or planning board or whatever. They have to have a site in mind when they're going and making decisions for these boards. And it can't be taken lightly because it affects the entire town.
Any other questions?
No.
Thank you so much, and I believe this goes to the Board of Selectmen
Yeah.
for approval, but
Well, we
we basically have to say, well, we will forward your name or not, is that how it?
Yeah, that's
Like,
Yeah.
yeah,
You
like
recommend
we
for
recommend,
for approval.
yeah, we
I'm-
recommend,
I move to recommend Louise Lester for the Zoning Board of Appeals.
I second that.
All those in favor?
Can I ask Mary a
Thank you. Good
Good
question?
addition. Go ahead, I'm sorry.
You wanna, wait, before we vote, go ahead and ask.
I thought you were done.
I just thought of something else.
Okay.
Sure.
Mary, is there anything that says we have to have more than one candidate?
No.
No.
Okay, now we can vote.
Okay, all those in favor? Thank you so much, Louise.
Now, I've got a question for you guys. Are you aware or have you been to any training for being on the appeals board?
Yes.
So that Maine municipal
Yep.
classes, because that was something I really would like to do.
Yeah, we had,
Everybody
we actually
goes.
we had Mary Costigan come in from,
But we also sent them to
Yeah.
yes,
the
Sent
in
them,
May.
yeah.
program,
Yeah,
and we
yeah.
will do, I
Yep.
will send you the information on that.
Only,
That's great,
Yeah,
that's great.
it's
Yeah,
fantastic.
I
and
definitely
know
need that.
Sometimes folks go to, and I'm not opposed to in the future going to a refresher session, so, I mean, it's always good.
Yeah, their classes are
They're
very
really-
good.
Yeah, and their website is very helpful as well.
Yeah.
Me too. So, great. Thank you so much, Louise. Yeah, you'd
Okay.
be wonderful. Thank you for,
Well, we'll see what
Stepping
the
forward.
selectmen say.
thank you.
thanks. Appreciate it. Okay, where's my agenda? I think, are we on to code enforcement officer communications?
I think we have nothing coming up at all. First time in a long time.
Great. All's
So, no,
quiet?
unless another one of those mortgage surveys comes up and kicks something else out. That's usually where they would come in at the spur of the moment, but
Yeah.
I haven't had anything come into our office yet.
No, so we're free for December.
All right. That sounds good.
It's okay, I'll give you Christmas shopping.
Okay, great. Anything else, anybody? Any communication? All right, thanks. Any motion to adjourn?
Second.
Okay, I'll motion to adjourn.
I motion that we adjourn the meeting.
All in favor? All in favor? Okay.